people are able to intimidate you, you are easier to then therefore manipulate and control. Cross-examination is not a personal attack from an attorney. I know we all believe that our ex's attorneys are terrible and they're despicable human beings. But there's maybe some truth to some of that. But them putting you on for cross-examination is not a personal attack. It is their strategy. What are they trying to accomplish with this? They are trying to ruffle your feathers. They are trying to get under your skin. They are trying to have you look crazy, right? To look not credible. It is pure strategy, right? If you've ever been in the courtroom waiting for your case to be heard, I'm sure that you have seen cases before yours where, the attorneys were really kind of getting into it with the witnesses, right? And the witness seems flustered. Maybe the witness even had gotten defensive at one point or another, right? So I think it's important that we recognize other cases as they're being presented in family court. And if you have the ability, I invite you to go sit in family court and just watch. Watch a few hours, see what's happening, so you can get a better sense of your presence and the overall moves that the different players in the family court system are taking, right? What is the role of the attorneys? How are they engaging with other individuals that are not me? And I'm not saying to go and observe opposing counsel, but just to get a general idea of how they always present. Here is a line that I think is really powerful for us when it comes to reframing. You are not on trial as a human being in family court. You are being evaluated as a witness, and those are two very different things. You are being evaluated as mom as well. We're going to talk about how to present evidence and verbiage and how to address the concerns that we have. And I'm going to give you some tips on doing that. If you are watching live in school, I will address questions that you leave in the Q&A. Now, many of us forget that part of being able to present ourselves and look credible and cool, calm, and collected is being able to regulate our nervous system on the stand. You'll see that even when I'm speaking to you, I take breaks. I might take a sip of water. I might pause. I might take a breath, right? Why do I do that? It helps me regulate my nervous system. There's some practical, teachable tools that I can give you to help when you're going and you're presenting your case or if you are testifying. And I work with everyone on these tips, right? Especially in our one-on-one sessions. But the first thing is grounding your feet on the floor. That's not sitting crisscross. That is sitting with your feet into the floor, allowing your weight to be shifted almost and pushing into the floor. Can you feel the floor? Where are your feet? Do you feel your socks? Do you feel your shoes? What does the ground beneath you feel like? And I want you to check in with your body as you do these things. Slow your breathing down. Easier said than done. If you are an individual like myself that has a lot of anxiety or can be triggered by being around their abuser, most of us have that scenario. Medication is something that you can lean on. There's no shame in this. Propranolol actually is something that helped me make it through. That and sertraline, which is like the medicine helped me to be able to do these things that I'm sharing with you. If we slow our breathing down, we can inhale for 4 and exhale for 6 counts. Dropping your shoulders, right? Putting your shoulders behind you, dropping your shoulders, unclenching our jaw. Where do we hold tension and stress primarily in our body? Our shoulders, our face, our jaw, unclenching it, relaxing. If your body is calm, your answers will follow while you're being questioned on the stand, or even if you're presenting your case, providing testimony, but this is largely focused on cross-examination. I want you to pause before answering. This is allowed. It's not the first one to answer the question is the winner. You're allowed to pause. Speak slower than feels natural. I don't always speak at this rate, right? I speak quite quickly with my children, my husband, friends. I want you to slowly speak, right? Slow your speech down. I promise no one is paying attention. If you don't understand a question that's asked to you on the stand, say that. I'm sorry, I did not understand the question. Could you please rephrase? If you didn't hear the question clearly, I'm sorry, I didn't hear the question. Could you please state it again? If you don't know an answer, if you don't remember an answer, say that. I don't recall. I don't know. Pausing in our testimony is not weakness. Pausing is us being in control. I want to give you a modern day example of someone that was very well prepared for providing testimony in a deposition. Was access offered? Did the child have the ability to take the call? Were they able to have access to the other parent? It's a yes or no answer. Now, well, yes, but no, it's yes or no. Stand at the damn weeds. Was the call made available? Did the other parent actually really call first and foremost? Because sometimes we all know that they say that they do something and they never did, right? Was the call made? Yes or no? Was the child available for the call? Were they at soccer practice at 6 p.m. when that call is ordered? Then obviously the call cannot occur if they're on the soccer field, right? Think of like what other components go into this. Is there any kind of parent interference in the calls? This goes both ways. Are you allowing the child to have a call all on their own and walking away? Please don't record your children speaking to the other parent. Please don't record your kids' phone calls. Don't do this. Please don't do it and don't play it in court. Like, it does not play out well for you. It makes you look controlling, domineering. While I know that your intent is keep your child safe and protected and you're concerned about the child, it does not appear that way. Back off a little bit. And if you've recorded calls, please do not use them in court. Do not use calls or anything that you've recorded from your child in court, because it falls into the story of, see, they're setting me up. They've been alienating me from the child all along, or that you're coaching the child. You're not coaching your child, but that is what is going to be spun. I guarantee it. If you're wanting what your child, thinks, feels, says to be a part of your case and have a judge pay attention to it, have legal professionals look into it more, it needs to come from a third-party neutral professional, a therapist, guidance counselor, a teacher, pediatrician, not from you. And not from you definitely recording the calls or any kind of interaction or having a video of the child. So if there's no obstruction from your part, right? And we're also trying to document for our own case that they're never allowing us to have communication with the child, right? Are they obstructing? Is there an ongoing pattern of obstruction from the other side? The answer is likely yes. I'm going to use myself as an example. A device was never provided to my children, so therefore they could not make the calls. That's obstruction. The courts do not care, guys, about the length of the call. If the call is a minute, if the call is 10 minutes, the courts don't care. And I've sat in courtrooms and I've heard these arguments of, well, I was only able to speak to them for a few minutes and I had more to say. And I've had judges tell people, I've heard them say it, do I need to teach you how to be an adult? One, of also asking an additional clarifying question. So you were able to have the call with the child, right? Okay, so what's the big deal? The length of that call is really irrelevant. They want to send for a wellness check? Cool. They want to blow up your phone? Let them. Does not mean that you take that call. That is you holding a boundary. The goal is not to be understood in your messages. The goal is for you to be undeniably the cool, calm, and collected parent, the one that is child-focused, the one that is reasonable, regardless of what they're saying. If you are sending messages to your high conflict ex with the hope and anticipation of you're going to get them to agree, you are going to be met with disappointment every single time. I know that that's unfair. I know it sucks, especially in shared legal custody situations. You might need their approval. They're not going to give it to you. They're not going to agree. And depending on what, some of these things are, you should have a third-party neutral professional recommending maybe the services that your child might need, the braces that they may need, right? The therapy. And from the years that I've been working with clients on communication, the biggest hurdle for everyone to overcome is radically accepting that you can't make your ex agree with you. We can't make them change their mind. And you'll notice in their communication style, they want to kind of gaslight you into agreeing. They want to manipulate you so that you agree. Little segue here off topic of communication. because this actually came up last week in a meeting that I had with a client, and I was actually sitting in with client and pattern viewer. There are some words that you all have used in the family court system, and these words are actually not effective to presenting your case, to showing that the other parent is high conflict. None of it. What are these words? It should already be registered in everyone's mind. You never want to use the word narcissist. It's a buzzword. It's overly used. And in the eyes of family court, it also kind of puts you into this place of, well, are you the parent or are you a mental health care professional providing a diagnosis? Right? We don't want to be doing that. Manipulation. Using the word manipulation. It's overly used. Gaslighting. It's overly used. Abusive. Emotional abuse. Overly used. Why are using any of these words now ineffective in family court? Well, because they've been overused, one. And also, what do we know about high conflict people? High conflict people mirror behaviors. They mirror behavior in individuals that they actually like, right? So they like the behavior. They like the way that you're communicating. They like the way that you're presenting yourself. They start to copy you. They are copycats. They don't have any authenticity. Okay. So they start to use these buzzwords. Alienation is another one. Oh my God. Alienation. They're alienating me from the child, right? We can talk about alienating behaviors and we can talk about them without really ever saying those words. Like, let's think about it for a second. If we were to, want to share how the other parent is, alienating you from the child, how could we show that? Great example. I see it all the time. It's their parenting time. The child has a basketball game and they want to make you believe that you cannot go because it's not your parenting time. Is that really accurate? No. But when this is a consistent pattern of behavior and they keep trying to bring these things up, what does that show us? That they are not supportive of the child having a relationship with the other parent. This is why when it's your parenting time, you should be proactively sharing information. If you do not have a protective order in place that would prohibit the high conflict parent from attending such events, the information should be shared. If they don't go to the awards ceremony at school, they're not going to graduation, they're not going to that chorus performance, all of the things, but you've shared it. None of that is your fault that they're not there. But what can we do by proactively sharing the information? I know it will make you feel very uncomfortable if they show up and they are there. You don't have to sit next to them. You don't have to speak to them. Your job is to be present for your child. But if we share the information with them, every single abusive ex who you have to co-parent with, every single one of them tries to push the narrative of how you are keeping them from the child. She's withholding the child. They're withholding the child. They won't let me see the child. They never let me go to gymnastics. They never let me go to soccer. They never let me. But if you've shared the information and you're independently tracking the behavior, you're documenting it, right? The child has gymnastics every single Tuesday. I've shared it with the other parent. January 1st, when they were signed up, they've been to one gymnastics practice, class, whatever it is, in the past 12 months. One. But they had the information. So whose fault is it that they were not there? Is that their fault or your fault? You miss who you thought they were. You miss the person they performed to be during the love bombing phase of the relationship. That person, that version of them doesn't exist. You're grieving a character. Have you heard the quote from William Shakespeare? All the world is merely a stage and all the men merely players. I used to love that quote. And I think it was something that helped me get through my life as a child for quite some time. I was a theater kid, right? And I would hold on to quotes and words that helped me survive the abusive situations that I grew up in, the abusive situations that were later parts of relationships. The most painful fantasy, it's not even like a reunion with this person.
It's the apology. The one where, they finally see what they've done wrong, how they finally realize that they hurt you. Maybe they've hurt your kids or they're hurting your kids. They take accountability and they apologize for their actions. Maybe they look you in your eye and say, I hurt you and I'm so sorry. That's not a fantasy about love. For me, it's a fantasy about justice. We're wanting to right this terrible wrong. We're wanting them to apologize because that's what we would do if we hurt another person. There's also like this alternate kind of timeline. If they had just gotten help, if I had just done this differently, if they had chosen me, if they hadn't cheated on me, maybe I could have done something different in my marriage. Maybe if I was like my brothers, I would say to myself, maybe I would have been seen. I lived in that timeline for years. As a little girl, I grew up always wondering if I was good enough. And believe you me, when I thought that I was doing great, I was immediately brought back to my reality that my stepmother and my father were conditioning me to believe, and that was that I was not enough. I was not good enough. I was a bad kid. Yeah. Here's the truth that I've come to learn is that no matter what we were doing, we would never get a different outcome because they were never going to be a different person. That timeline doesn't ever exist, you see. For me, I thought that, okay, well, if I get all of my chores done and I get them done so perfectly and everything's great, like my stepmom is going to be kind to me today. She's going to be so proud of me. She's going to tell daddy, and I'm going to be like, wow, dad's going to like love on me and be so happy that there were no problems today. That never happened. Maybe my dad will stand up for me and say something to my stepmom to defend me, protect me.
So if your high conflict ex has a high powered attorney and you don't, right? The gal in your case may have been handpicked to favor that side. Okay. Just this is not paranoia. It is a known documented conflict of interest. And I don't say that for you to feel fear. I say that to educate you and provide you with knowledge to kind of power you into the future, knowing what can protect you and your child. What does actual bias look like in these cases? So, some red flags overall, right? So, like grounds to challenge a gal report include bias, conflict of interest. If the gal appears to favor one parent, without a factual basis, incomplete investigation if the gal failed to interview key witnesses, right? Did they not interview you? Relied heavily on hearsay without maybe verifying facts. There's factual inaccuracies in the report. The gal had improper conduct or qualifications of that gal if the gal is overstepping their authority or lacks, the necessary training to do their job well and efficiently. Specific behavioral red flags that I tell my clients to be on the watch for are if the gal is spending significantly more time communicating with one parent than the other, such as is there a 30-minute call with one parent while having much more extensive contact with the other. This, for me, would raise questions about neutrality. A major red flag if a gal is, tries to avoid a deposition. For me, that's a red flag. If they try to avoid a deposition or any formal questioning, gals whose opinions are well researched and unbiased, they should be able to defend those opinions. They should be able to give you copies of all of the things, documents that they obtained in their investigation to come up with their report.